So we start first with Jennifer.
Kia ora, Kate, and a special welcome to our New Zealand colleagues. It's fabulous to be able to have this webinar with you. Before I start, could I acknowledge the traditional owners of the land upon which I sit, who are the Wurundjeri people of the Kulin Nation, and pay my respects to their elders past and present. So whatever else one might say about the Family First case, it's clear that its progress through the legal system has been at a glacial pace. The Family First saga started 13 years ago on the 18th of May 2007. On that day, Family First was approved as a charitable entity by the Charities Commission and registered under the New Zealand Charities Act 2005. The Family First Trust Deed sets out 6 purposes and aims of Family First, namely to promote and advance research and policy supporting marriage and family as a foundational to a strong and enduring society, to educate the public in their understanding of the institutional, legal and moral framework that makes a just and democratic society possible, to participate in social analysis, to produce and publish relevant and stimulating material in newspapers, magazines and other media, and to carry out such other charitable purposes within New Zealand as the Trust shall determine. Family First's view is that a natural family is the union of a man and a woman through marriage for the purposes of sharing love and joy, of raising children, providing their moral education, building a vital home economy, offering security in times of trouble, and binding the generations. Family First opposes the liberalisation of laws relating to divorce, prostitution, abortion, child smacking, cannabis, and euthanasia. It has produced a number of booklets on these topics, advancing a particular viewpoint. Many of the authors have considerable status. Family First has also commissioned research on the financial benefits of marriage and the financial costs of family breakdown. It also hosts an annual forum on the family. Finally, it will often produce short opinion pieces on topics and lobby for law change. About 9 months after Family First was approved as a charitable entity, the Charities Commission made an inquiry of Family First about the extent to which its activities involved advocacy. In its reply, Family First simply stated that it's never been and is not our intention to directly lobby MPs in our ongoing work. Our focus is on education, research, and encouraging public debate. 16 months later, in June 2009, the Charities Commission advised Family First that it was conducting a review of its operations to ensure that it's still qualified for registration as a charitable entity. 9 months after that, the Charities Commission concluded that Family First did, in fact, continue to be qualified for registration as a charitable entity. Nearly 2 years later, the Charities Amendment Act 2012 came into force, which replaced the Charities Commission with the Charities Board and transferred the functions of the Charities Commission to the Department of Internal Affairs and to the Charities Board. The Amendment Act did not change any law relevant to the question of whether Family First qualified for registration as a charitable entity. In September 2012, 7 months after the amendments took effect, the department advised Family First that it intended recommending to the Charities Board that Family First be removed from the Charities Register. This recommendation was based on the department's view that Family First's purposes involved advocating and promoting a political viewpoint, which, in the department's view, was not a charitable purpose. This advice was accepted, and despite a detailed response by Family First, the board resolved to deregister Family First in April 2013. Family First appealed to the High Court, which is the equivalent to the Australian Federal Court. The hearing of that appeal was deferred until after the Supreme Court, which is equivalent to the Australian High Court, delivered its judgment in the Greenpeace case, which was in August 2014. After this, the first Family First High Court decision was handed down by Justice David Collins in June 2015. Justice Collins recited Section 5 of the Charities Act, which provided that a charitable purpose includes every charitable purpose within the conventional four heads of charity, and noted that the entity's purpose must be of public benefit, which will be assumed under the first three heads, but must be expressly established under the fourth head. His Honour noted that a non-charitable purpose will not preclude registration if it's merely ancillary to a charitable purpose. He pointed out that an entity's activities must not be conflated with its purposes, but that its activities may be of assistance in assessing various issues, including whether the entity's purposes provide a benefit to the public. Justice Collins also noted that in making its decision to deregister Family First, the Charities Board were heavily influenced by its understanding that Family First was engaged in political advocacy, and by its understanding that political purposes could not be classified as charitable. However, the board decision was made before the Supreme Court delivered its decision in Greenpeace. In the Greenpeace decision, the Supreme Court held that political purposes were not irreconcilable with charitable purposes. As such, Justice Collins allowed Family First's appeal and directed the Charities Board to reconsider the case in the light of the Supreme Court decision in Greenpeace. Justice Collins noted that the analogical analysis which the Charities Board was required to undertake when reconsidering their decision should be informed by examining whether Family First activities are objectively directed at promoting the moral improvement of society. This exercise should not, he said, be conflated with a subjective assessment of the merits of Family First views. In August 2017, the Charities Board reconsidered its decision and reached the same decision. Family First appealed to the High Court again, and Justice Simon France handed down his decision dismissing the appeal in August 2018. He held that the narrow issue in these advocacy cases is whether a body whose main or indeed sole function is to promote a viewpoint is a charity. The advocacy cases where charitable status has been acknowledged are scarce, he said, and seem increasingly limited to purposes of almost universal acceptance. Here, he said, it cannot be shown that Family First promotion of the traditional family unit, though no doubt supported by a section of the community, if achieved, would be a public benefit. If it is achieved at a cost to other family models, it could affirmatively be said not to be in the public interest. Family First appealed to the Court of Appeal. As Kate mentioned, the Charity Law Association of Australia and New Zealand, CLAANZ, sought leave to appear before the Court of Appeal as an intervener. CLAANZ did not seek to support either side of the case, but rather addressed the court on two issues relevant to the appeal. The first issue was whether, in determining whether a political advocacy organisation exists for a charitable purpose of public benefit, wider benefits flowing from the means and manner of its political advocacy, including from the fact of the advocacy itself, should be taken into account. The second issue was whether a political advocacy organisation exists for a charitable purpose of public benefit cannot be considered in isolation from the implications of its freedom of political expression. In addressing these issues, CLAANZ sought to draw the court's attention to relevant jurisprudence from around the common law world. Consequent upon CLAANZ obtaining leave to appear, the Respondent Charities Board was replaced by the Attorney General, who sought to uphold the decision of the Charities Board. As Kate mentioned, on 27 August this year, a majority of the court allowed Family First's appeal. I'll hand over to Professor Harding to discuss the Court of Appeal decision. But before I do, I note that a few days ago, as Kate said, on 24 September, the Attorney General filed an application for leave to appeal the Court of Appeal's decision to the Supreme Court. And so the saga continues. Over to you, Matthew.